Hello, everyone. Thank you for joining us. I'm here today to coordinate this United GIP webinar series with Mr. Kenneth Fagin. Ken is a U.S. patent attorney with more than 30 years of experience and specializes in obtaining patents for clients worldwide in various technologies. As Ken explains, he has always been fascinated by how things work, with one of his favorite childhood books being What Makes It Go, What Makes It Work, What Makes It Fly, What Makes It Float. He received a degree in aerospace engineering from MIT, and then he worked for 2 years at McDonnell Douglas, an aircraft manufacturing company, before starting law school. In addition to patent prosecution, Ken provides clearance advice, handles litigation matters, and patent validity challenges. He is admitted to practice in various state and U.S. courts. Ken believes in advocating for clients' intellectual property rights, and he seeks to navigate the Patent and Trademark Office's rules as cost-effectively as possible. As Ken puts it, it's the client's IP. Protect it. It's the client's money. Keep it. For any questions or comments with today's webinar, please email Ken at kfagin@unitedIPlaw.com. Now I'm going to turn our presentation over to Ken.
Good afternoon, everybody. Thank you for the introduction, Crystal. Today we are going to speak about cost-effective prosecution. And by this, I mean obtaining for our clients the broadest possible scope of patent protection and trying to reduce or minimize the cost to do so. First, we're going to talk about some substantive principles for responding to a Section 102 or a Section 103 rejection. And then I want to speak about some procedural considerations involved with responding to or dealing with finality of an office action or responding to an election or a restriction requirement. Some of what I talk about today may seem fairly fundamental or elemental or basic, but as I like to point out, the difference between a Little League baseball team and a Major League Baseball team is how the Major League players execute on the fundamentals of the game. There are some practitioners who view patent prosecution as a negotiation with the examiner, where they figure, okay, fine, I'll give the examiner this. If the examiner gives us that, then there are some practitioners who have described patent prosecution as being like a game of chess with the examiner, where they are trying to manipulate or maneuver the examiner into a position where the examiner has to concede. We tend to disagree with these two philosophies or approaches, although note that I do have an asterisk by the chess match, because as we go through prosecution, it is important to keep in mind how an examiner will respond to what we do or say in the application process. Our approach, on the other hand, tends to be more of an advocacy-based approach. In other words, it is our attitude that an applicant is entitled to patent protection unless and until an examiner establishes otherwise. And this approach or philosophy is, in fact, reflected in the preamble to 35 U.S.C. Section 102, which is the novelty statute, which says a person shall be entitled to a patent unless. So in other words, we start with the presumption that the applicant is entitled to a patent, and it's up to the examiner to show otherwise. Sometimes as we go through prosecution, it's helpful to keep in mind how an examiner approaches things, or to realize what the examiner's mindset is. And I think perhaps the biggest thing to keep in mind is that in the US, examiners search the claims, not the inventive concept. And what I mean by this is that the examiners will take a very literal approach, and they will look for the exact words of the claims as shown to be shown in the prior art. They don't step back and say, okay, I understand what this invention is all about, what these claims are talking about or trying to talk about, and search on that. In other words, they will treat the claims like a shopping list of ingredients to go look for in the prior art. Also in the US, examiners are supposed to give claim language its broadest reasonable interpretation in light of the specification as it would have been understood by a person of skill in the art. Unfortunately, frequently, examiners will give claim language the broadest possible interpretation, even though it's clear that the interpretation the examiner is giving to the claim language is not what was intended in light of the specification. Additionally, it is frequently important to keep in mind that examiners have limited time to examine a patent application, and examiners have high productivity requirements. And so many times it can seem as if the examiners are simply going about things very methodically or robotically and not really thinking about what a given application is all about. This link that I've provided here to the Reddit forum provides an interesting window into the frustrations that examiners frequently face as they are trying to do their jobs. And it can be sort of provide some interesting insight. There are certain practitioners who will take what an examiner says at face value, and their automatic approach or automatic response is simply to add limitations to the claim to get around the prior art. The reason we tend not to take that approach is because the more elements that you put into a claim, the narrower the scope of protection becomes, and the less valuable a given claim might be. Because after all, in order to establish infringement of a given claim, all elements of that claim have to be found in an accused device or an accused method. So the more components you list in a given claim, the narrower the scope of protection of that claim becomes. There's also another reason why we don't just put in limitations to get around the prior art in response to any and every anticipation or any and every rejection the examiner gives us. And this has to do with enforcing a patent in litigation. During litigation, we can show infringement two ways. There can be literal infringement, which means that each and every element of an asserted claim is possessed by the accused product or method, or we can rely on the doctrine of equivalence, which I refer to as close enough. And what this means is, even if there is some claim element that is not exactly possessed by the accused product or accused method, if what the accused product or method has performs, for example, substantially the same function in substantially the same way to obtain substantially the same result, then we can hold the accused product or method, or that product or method can be held to infringe under the doctrine of equivalence. However, if a given element was added to a claim during prosecution for any purpose of patentability, then the patentee cannot rely on the doctrine of equivalence to establish infringement with respect to that given element. And so for this reason, if there is a way to respond to an examiner without simply adding elements to the claims, we will do so. Dealing with a Section 102 rejection. But even here, in the context of Section 102, responses still require advocacy. The easiest situation to deal with is an examiner has simply overlooked or missed one of the elements recited in the claims. Pardon me, but that is not usually the case. Rather, what is more frequently the case is an examiner is giving the claim language an interpretation that was not necessarily expected. The examiner is supposed to, again, the examiner is supposed to give claim language broadest reasonable interpretation, but sometimes they give the claim language an interpretation that is so broad that it has nothing to do with what the invention is all about. Nevertheless, simply saying to the examiner, hey, examiner, your interpretation is overbroad to the point of ridiculousness or unreasonableness is not likely to get the examiner to change their mind and withdraw the rejection. What we frequently need to do is figure out how is the examiner interpreting the claim language and how can we sharpen the claim language to clarify the claimed invention or distinguish what we are talking about in the application from what is shown in the prior art. Responding to a Section 103 obviousness rejection, on the other hand, this is where the advocacy skills tend to come into play a little bit more. Prior to about 2007 and the bedrock case of KSR, the typical response was that an obviousness rejection, or to establish an obviousness rejection, the examiner had to show some teaching, suggestion, or motivation in the prior art to make the combination of references or to modify the base reference to meet the claim language. But when in KSR, the US Supreme Court basically said, no, teaching, suggestion, or modification is not the touchstone or the requirement for obviousness. In 2024, the courts and the PTO adopted an even more flexible approach to establishing obviousness. Even just common sense can be used as a reason to modify a base reference, either in view of another reference or even just taking the base reference by itself and making some changes to it to obtain the claimed invention. Nevertheless, despite the more flexible approach to establishing obviousness, that is the modern approach, there still has to be a rational reason or a well-articulated reason why a person of skill in the art would not have modified a reference. The considerations for responding to an anticipation rejection still apply. For example, if every element in the claim is not established by a reference or a combination of references, then that is one basis on which to respond to a Section 103 obviousness rejection. But more often than not, what we get into is having to evaluate what is the logic that the examiner is applying and how do we counteract or counter-argue that logic. For example, if an examiner says that it would be obvious to add element A to a base reference because A gets you X result, but A really doesn't really lead to X result, we might attack on that basis. It's also important to keep in mind that obviousness is based on facts, not conjecture. So if it can be shown that what the examiner is saying has no basis in fact, that the examiner is just making things up or hypothesizing, that is one way in which we can respond to an obviousness rejection. Like I said above, the Section 102 considerations come into play. So if there are missing elements in what the examiner says, then the examiner has not recreated the claimed invention, so to speak, and they have not established a prima facie case of obviousness. When we respond to an obviousness rejection, it is always, always, always important to argue against what the examiner is saying, not to try to come up with other reasons, but rather to argue against the examiner's position. Some places where we see non-US practitioners have difficulty, if you will, in responding to an obviousness rejection is they will look at a preferred embodiment in the primary reference and will say, oh, okay, the reference teaches to do this. And the reference teaches against or teaches away from what we are doing. But what's important to keep in mind is that simply showing, when a reference shows a preferred embodiment, the simple fact that a reference shows a preferred embodiment does not mean that the reference is teaching against any other embodiment. So disclosure of a preferred embodiment in and of itself is not teaching away. One of the other things that we frequently see sometimes, it's actually an oxymoron. What we sometimes see is our foreign colleagues will interpret what the examiner is saying as the examiner is saying that a secondary reference will be literally or bodily or completely added to the primary reference. What is important to keep in mind is that the examiner is simply looking at a secondary reference for the disclosure of some little bit of a concept that can be added into the primary reference to obtain the claimed invention. Sometimes we get response instructions that are based on special effect. In other words, what does the claimed invention accomplish? In the US, the examiners tend not to look at a special effect. But again, the examiner will look at what are the literal words of the claim and what does the claim recite. And so for that reason, when we respond to an obviousness rejection, we really do need to get into the logic of the examiner's position. Sometimes our colleagues will ask us to argue based on surprising results obtained with the claimed invention. When it comes to surprising results, it's important to remember or to keep in mind that in order for results to be surprising, they really do need to be surprising. In other words, the result obtained with the claimed invention is not just merely, or the claimed invention is not merely the product of optimizing individual components, but rather there really is some sort of benefit that would be obtained that a person of skill in the art would not have expected. Dealing with a Section 103 rejection takes all advocacy skills to obtain or to maintain the broadest reasonable or the broadest possible scope of protection for the client. Sometimes we get instructions to argue about the invention behind an application, not the claims, but again, in the US, the examiners are examining the claims, not the inventive concept behind the application. Sometimes we will be asked to argue what the claims mean based on what is disclosed in the specification. But sometimes if things that are disclosed in the specification are not reflected in the actual claim language, when we make those kinds of arguments, the examiner will come back and say that we are trying to read in limitations from the specification. In other words, making something that is shown in the specification into one of the claim recited elements. Sometimes we are asked to argue more broadly than the claim. In other words, that takes a bigger picture view of what the claim recites, and that tends not to be effective. And frequently, we will see arguments that the examiner is relying on hindsight. hindsight is perhaps one of the most difficult arguments to make in prosecution because the examiner has already come up with this rejection and they think that it's legitimate. And so simply saying, oh, Mr. or Miss Examiner, you're using hindsight. Well, hindsight always goes into making any rejection. The examiner has to know what the claim says in order to go out and find references to apply. So hindsight is always part of the process. Merely asserting hindsight is not likely to convince the examiner to withdraw a rejection. In order to establish a hindsight-based rejection, you really need to show that the examiner is relying on nothing more than what the applicant discloses in the application in order to make the rejection. Once again, dealing with a Section 103 requirement or a Section 103 of rejection requires all of our advocacy skills. Turning now to some procedural considerations where the cost of where what we do can affect the cost of prosecution, and where it's important to keep in mind basic principles in order to minimize or reduce the cost of prosecution. Finality of an office action. When we file a patent application with a set of claims, the examiner says, nope, those claims aren't any good. They reject the claims. If we add some more limitations to the claims, whether they're more limitations or if we sharpen or clarify some of the limitations, if the examiner comes back with a new ground of rejection, and that new ground of rejection was the result of something that we did in amending the claims, the examiner will make the new office action final. And the reason finality is challenging or difficult is because our ability to amend the claims further after final is somewhat constrained, which is why I've got the handcuffs shown here. Also, in contrast to a non-final rejection where once we file a response, we have satisfied the time requirements, after final, the clock keeps on ticking until we have either gotten the case allowed or filed a notice of appeal or filed an RCE. So if we file a response to a final office action at the 3-month date, and yet we don't get any results from the patent office until, say, the 5 or 6-month date, when we have to do something else, we might have to pay for 3 months of extension, 2 or 3 months of extension in order to file the next paper with the patent office. In other words, we haven't stopped the clock when we file the response after final. Finality is also challenging, and this is where the cost of prosecution can really go up. If we have a final office action and we need to make some claim amendments that are rather substantial, in order to get those substantial claim amendments entered and considered, we frequently need to file an RCE, i.e. a request for continued examination. And this is where things become fairly expensive. The first RCE, by the way, the cost for all PTO costs, by the way, are going up as of January 19th. The cost for an initial RCE in an application will go up to $1,500 for a large entity or $600 for a small entity, and that is a 10% increase in the cost of an RCE. For second or subsequent RCEs, the cost will be going up by 43% January 19th. For a second or subsequent RCE for a large entity, the cost will be $2,860 for a large entity, or $1,144 for a small entity. In addition to cost, filing an RCE extends prosecution, it introduces delay, and because the term of a patent is based on filing date of the application, the longer it takes to obtain that patent, the shorter and shorter and shorter the term of the patent becomes. So we do try to minimize finality, or we try to minimize, or avoid finality of an office action in order to avoid the need to file an RCE, and in order to maintain as much term of the patent as possible. Because of this, we try to push back against finality of an office action if possible. If a new office action, if a final office action contains or includes any new ground of rejection that was not necessitated by something we did, something that we said, or an argument that or an amendment that we made, then the new office action is not properly made final. And in assessing ground of rejection, what we look at is the thrust or the essence of the examiner's argument. If that has changed and we did not amend the claims, the subsequent office action is not properly made final. In this situation, it's important to contact the examiner and explain to the examiner that the final office action was not properly final. And as I note here, timeliness is important. When we get a final office action, the first thing that we look at is whether finality is in fact proper. And if it's not, we'll pick up the phone and contact the examiner and explain to the examiner why the rejection is not properly final, so that the examiner can issue a new office action that is non-final. Turning now to restriction and election practice. This is an area of practice where an applicant can actually spend money that is for naught. As you may know, in the US, we are entitled to 3 independent claims and up to 20 total claims when we file an application. Independent claims in excess of 3, we have to pay a surcharge, which will be going up to $600 for each independent claim over 3 as of January 19th. And that's $600 for a large entity, or $240 for a small entity. And every claim in excess of 20 will now cost $200 surcharge for a large entity, or $80 surcharge for a small entity. And by the way, these surcharges are the same for national phase applications as well as Paris Convention applications. So the more claims we put in, the more expensive an application can be. Unfortunately, with restriction and election of species requirement, when the examiner says, oh, no, I'm not going to examine all the claims you have put into the application, and we have to withdraw certain claims from consideration, we don't get a refund on non-examined claims. So in other words, that can be seen as money that has gone down the drain for all these extra claims that are not going to get examined. For this reason, by the way, in addition, there are some considerations that come up having to do with obviousness type double patenting or terminal disclaimers, and these will be addressed below. So it's not only a matter of additional cost or money that is spent on an application for extra claims that doesn't really obtain or get us any consideration of these claims, but these other considerations come into play as well. A restriction basically means there's more than one independent and distinct invention in an application. The idea behind restriction practice is that there should be one invention per patent. So if you have two different inventive ideas or two different inventions, you need to obtain two different patents, not two different inventions in a single patent. Election of species practice, on the other hand, actually, let me step back a second. For a restriction requirement, when we respond to a restriction requirement, the real question is, what is the fundamental nature of the invention? Is it methodological or is it apparatus in nature? And who is the patent owner going to assert the patent against? This will guide what set of claims we select in response to a restriction requirement. Again, the question is, what is the more important or the more meaningful set of claims to pursue in the given application? Election of species practice, on the other hand, is where an examiner says that there are claims in this application directed to multiple independent and distinct inventions. Now, you'll notice that I have said, or I've put "or" in parentheses. The language that is used in the MPEP is claims to multiple independent and distinct, as if there are two different requirements to be shown in order for an examiner to impose an election requirement. But in practice, the examiners have treated this as if they are alternative requirements for establishing an election of species requirement. Additionally, an examiner has to show there is supposed to be serious burden on the examiner in having to examine all claims in the application. When we are faced with an election of species requirement, it's important to push back against the examiner's assertion of burden. In other words, we will argue or contest the examiner's demonstration that there's substantial burden in having to consider all claims. Sometimes we will push back against or contest the manner in which the examiner has divided up the claims in the application into different species of invention. In responding to an election of species requirement, it's important to keep in mind that an election requirement is supposed to be based on claims, not just the figures. So if we have an examiner base an election requirement simply on what the various figures show, but without regard to what the claims actually recite, we can push back against the requirement on that basis. In responding to an election requirement, or when we respond to an election requirement, we are supposed to identify claims that are readable on the elected species of invention. In other words, when we respond to an election requirement, we say, okay, we are going to choose species A, B, C, D, etc. And then we have to identify the claims that are readable on it. Now, one place where a lot of practitioners lose or give up certain claims from being considered is they do not properly apply the language that is used. what we are supposed to do is identify claims that are readable on. And what readable on does not mean shown in the given figures for or corresponding to an elected species. Readable on means not inconsistent with. So in other words, so long as something shown in the various figures can include terms that are recited in a claim, then the claim can be readable on. In other words, if a figure corresponding to an elected species shows, for example, a square peg or a square hole, and the claim recites round hole, well, then that would be inconsistent. But if the figure shows square hole and the claim is talking about something completely unrelated to holes, then a given claim can be readable on what's shown in the figures. And again, readable on simply means the claim is not inconsistent with a selected or an elected species. So when we identify or select a species of invention for prosecution or initial examination in the application, one way of approaching it is what species will get us the most claims to be examined. Another thing to keep in mind, or one thing to think about when we elect a species in response to an election of species requirement, is what is the most commercially important embodiment to the client. So there's a couple different ways to approach responding to an election of species requirement to maximize the value of the application or to get the most out of a given application. In addition to identifying claims that are readable on the elected embodiment, we are, let me step back. It's not a requirement that we identify generic claims. The examiner will frequently say, okay, such and such claim or claims are generic, meaning readable on all disclosed embodiments or just all disclosed species of invention in the application. Frequently, the examiner will say, okay, claim 1 is generic, but often more than one claim is generic or readable on all disclosed species of invention. And it's important to, as part of the response to an election requirement, to identify all generic claims. And the reason this is important is because once we get a generic claim allowed, all claims can be rejoined to the application. Claims that depend from the generic claim will automatically be rejoined. Now, this part of the presentation might be a little bit dense, and it's something that a lot of practitioners do not keep in mind or do not think about when filing an application with a lot of claims. There is this concept of obviousness type double patenting, which means there are claims in two different applications that are all directed to substantially the same subject matter. And when that happens, we will often get a rejection for obviousness type double patenting. And the way we can frequently deal with that is by filing a terminal disclaimer which says, okay, I'm giving up the portion of patent term of the one application that will extend past the patent term of the other application. But one of the downsides to that approach to overcoming an obviousness type double patenting rejection is if we file a terminal disclaimer to overcome a double patenting rejection, the problem with that is the two patents that issue on the two applications where double patenting came up will always be linked to each other so that they can't be assigned to different entities. Otherwise, they will become unenforceable. Additionally, if we file a terminal disclaimer to overcome a double or an obviousness type double patenting rejection, that applies to all claims in the patent, regardless of whether a given claim caused obviousness type double patenting or not. So in other words, it is or as I indicate here, it's like trying to, kill a fly with a missile. It's overkill. So we want to be careful, or we want to avoid situations where, or we want to minimize using terminal disclaimer to overcome an obviousness type double patenting rejection if possible. So how does this come up in connection with, or how do these concepts come into play in connection with minimizing cost or in connection with election practice? Well, there's a choice to be made. On the one hand, if an examiner imposes an election of species requirement or a restriction requirement, what this means is, according to the examiner, the claims that are subject to these requirements, in other words, if they are in different groups, some claims are in group 1 and other claims are in group 2. What the examiner is essentially saying is that the claims in these two different groups are patentably distinct. And so if the claims are patentably distinct and an examiner imposes a restriction or an election requirement, and we file a divisional application to pursue the second set of claims that weren't pursued in the first case, then the examiner is not allowed to, or is not permitted to make a double patenting rejection later on. So turning now to restriction and election of species practice, this is an area where a lot of money can be wasted. In the United States, we are allowed 3 independent claims and 20 total claims for the basic filing fee. And there is a surcharge for each independent claim in excess of 3 and each total claim in excess of 20. For independent claim in excess of 3, the surcharge large entity is $600. That's actually, that it'll be going up to $600 as of January 19th. And the surcharge for each independent claim in excess of 3 for small entity will be going up or increasing to $240 as of January 19th. For total claim in excess of 20, the surcharge will go up to $200 as of January 19th for a large entity, and for small entity, it will increase to $80. So, and by the way, this is the same for national phase applications as it is for Paris Convention applications. So frequently we will see applications that are filed with 4, 5, 6 independent claims and 25, 30 total claims, and there will be a lot of money spent for these extra claims. What happens frequently is these applications are subjected to a restriction requirement or an election of species requirement and an election will be made, and a lot of the claims that have been paid for will not get examined in this application. And unfortunately, we don't get refunds for non-examined claims for which we have paid a surcharge. And so, unfortunately, in many respects, that's like money going down the drain and client not getting the benefit of the funds they have expended for their patent application. And for this reason, we tend to take a fairly robust response to a restriction or an election of species requirement. In addition to the cost considerations, there are considerations with respect to obviousness type double patenting and terminal disclaimer, which we will address below. Restriction requirement, basically the idea is one invention per patent. And so rather than having one patent with two different inventions, independent and distinct inventions disclosed and claimed, or actually claimed is more important than what's disclosed, an applicant will be required to have two separate patents, one for each invention. In terms of responding to a restriction requirement, it tends to be a little bit more straightforward. We look at what is the fundamental nature of the inventive concept. Is it a method? Is it an apparatus? What is the real heart of what the inventors came up with? And we will use that to guide our response, or we will also consider who is the potential infringer and what claims will be the easiest to enforce against a potential infringer. That can guide our response to a restriction requirement. On the other hand, election of species, this is a place where a lot of practitioners don't get things exactly right in the response. Basically, an election of species requirement arises when an examiner believes that there are claims to multiple independent and distinct inventions in the application. You'll notice that I have indicated the word "or" in parentheses, and this is because although the relevant language in the MPEP speaks in terms of independent and distinct, in practice, examiners treat those as two separate or alternative requirements. But basically, independent and distinct means patentably independent or patentably distinct inventions. So the examiner will divide things up into different species of invention. The examiner has to show that there are claims to independent and distinct inventions. Additionally, the examiner has to establish that it would impose serious burden if he or she needs to examine all applications that have been presented in the application. Because it can frequently be money that is down the drain, so to speak, when there is an election of species requirement and claims don't get examined, we will push back. We will push back on the examiner's assertion that it imposes burden, and not just any burden, but undue burden, to have to examine all of the claims in the application. Sometimes the way in which the examiner has divided things up into different species is not exactly correct. For example, we just had a recent application where there were 4 different figures in the application, and the examiner said, oh, there's 4 different species of invention here. And what we pointed out to the examiner is, no, examiner, you're wrong. 3 of those figures all pertain to a given embodiment of invention. And so sometimes we push back on the way, or by pushing back, I mean we contest the way in which the examiner has divided things up. It's also important to remember that election of species is supposed to be based on claims in the application, not the figures. So if you had 4 or 5 different bodies disclosed, but all of the claims all pertain to all of those different embodiments, so they're not separate and distinct inventions covered by the various claims, then election of species makes no sense. Again, the analysis depends on, or supposed to be focused on the claims, not just the various figures. So when we respond to an election of species requirement, again, keeping in mind that we want to get examination of the most possible claims possible. And we don't want the client's funds to have been squandered. How do we go about electing a species for examination in the given application? First off, when we elect a species in response to an election requirement, we are required to identify claims that are readable on the elected species. Many practitioners think, oh, readable on means, or claims to be readable on an elected species, the elected species has to show what is recited in the claim. But that's not exactly it. Readable on does not mean shown in the elected species. Readable on, meaning it can be read on, simply means not inconsistent with. So as long as a claim is not contrary to something that is shown in the elected species, I will say that claim is readable on the elected species. So with this in mind, when we are asked to select a species for examination in the application, there's 2 things that we can consider. Which species has the most claims readable on it, which will allow us to get the most claims examined in the application. Alternatively, we will consider which species is most commercially important to the client, and we will select that embodiment or that species of invention for examination in the application at that time. In addition to selecting a species for examination and identifying claims that are readable on it, we will also identify claims that are generic to the elected embodiment. The reason it's important to identify claims that are generic is because if we get a generic claim allowed, all claims that depend from that generic claim will be brought back into examination, even if the claims are directed to other embodiments. And in an election of species requirement, we will frequently see the examiner say, oh, only claim 1 is generic. Or sometimes we even see an examiner say no claims are generic. Whereas when we go through and examine or evaluate the claims, we will identify multiple claims that are generic to all disclosed species of invention. And so it's important to identify all claims that are generic so that we can get the most claims examined or the most claims allowed in a given application for the funds that have been spent. Now, this next section might be a little bit esoteric, and it is something that a lot of practitioners really don't keep in mind when they are putting all these different claims into a given application. For this part of the presentation, it's important to understand the concept of obviousness type double patenting. Obviousness type double patenting arises where an applicant has claims in two different applications or an application and an issued patent that are directed to essentially the same subject matter. And an examiner will issue an ODP rejection because the basic idea, by the way, is to prevent an applicant from getting more term for an inventive concept, more enforceable term than they are ordinarily entitled to. So if there are claims in one application that are directed to an obvious variant of claims in another application or an already issued patent, the examiner will impose this obviousness type double patenting rejection. Typical way of dealing with that is to file a terminal disclaimer, which basically means that both patents will expire at the same time. It's the very convenient, very quick and easy way to overcome a double patenting rejection. The drawback to filing a terminal disclaimer, however, is that when you file a terminal disclaimer, the two patents are inextricably linked together, are inextricably linked to each other. And basically what that means is the patents that are related by the terminal disclaimer can't be assigned to separate parties. Otherwise, neither patent will be enforceable. Additionally, filing a terminal disclaimer is like trying to kill a fly with a missile. It's overkill. And what I mean by that is a terminal disclaimer will apply to all claims in the patent issuing in connection or issuing on an application in connection with which the terminal disclaimer was filed. So even if there is a rejection of just a single claim in a patent for obviousness type double patenting, if there are 19, 20, 30 other claims, all claims in that issued patent will be covered by the terminal disclaimer. So it is a fairly overkill kind of a response or overkill way of dealing with obviousness type double patenting. For this reason, if we are faced with an obviousness type double patenting rejection, we will push back on it. We will force the examiner to establish or to prove that these claims really are directed to nearly identical or obvious variants of each other. When responding to an ODP rejection, it's important to make the examiner show a claim-by-claim comparison. It's also important to make the examiner show that the one set of claims really is an obvious variant of the other set of claims. And as I mentioned, terminal disclaimer, it applies to all claims. And for that reason, we will wait to see how the claims evolve during prosecution before we file a terminal disclaimer, because it could be the case that by the time claims have been amended in order to secure allowance, obviousness type double patenting will no longer apply. Here's where the cost considerations come into play. As you see here, there's a balance to be made between patent term and fees that you might pay to have a whole bunch of claims put into an application. Here's what I'm talking about. As I mentioned, a terminal disclaimer makes two patents expire at the same time. And so term that you might have had on a later filed patent application can be cut short. On the other hand, if you put a whole bunch of claims in a patent application, you might be paying a lot in surcharge only to have those claims never examined in the given application. what's this? Here's how this choice arises. If there is an election of species requirement or a restriction requirement, and you withdraw certain claims from the given application and you file a divisional application to get those other claims examined, those claims cannot then be used as the basis for obviousness type double patenting. Or actually, I flipped that relationship around. If you withdraw certain claims and you file those claims in a divisional application, the parent application, the claims in the parent application cannot be used to make an obviousness type double patenting rejection against the claims in the divisional application. And this makes sense because remember, I said the basis for a restriction requirement or an election of species requirement is the examiner's assertion that the claims are independent and distinct from each other. So if you file these claims later on in another application, then they can't be deemed to be obvious variant of the other claims. So for this reason, if we are forced to file a divisional application, the examiner cannot lodge an obviousness type double patenting rejection against these other claims. And so if we want to get the maximum term for a given claim, what we can do is put all these different claims into a given application. And if the examiner comes along and issues a restriction requirement or an election of species requirement, and then we file a divisional application for those non-elected claims, those claims are safe from ODP and they will get longer term. The downside to doing that, however, is we might end up spending an awful lot of money to have all of those claims put into the first application, only to have them divided out or restricted or election of species out for a later application. So, like I said, what we come down to is a balance or a choice between patent term and the cost of an application due to excess number of claims that are never examined. And with that, I would like to thank you. And if there are follow-up questions or if you would like some clarification on any of the topics that I've touched on here, feel free to send me an email at kfagin@unitediplaw.com. Thank you for your attention. And with that, back to you, Crystal.
Thank you, Ken, for your presentation. Thank you to everyone for tuning in to today's webinar series. As Ken mentioned, please remember, for any questions or comments, please send him an email at kfagin@unitediplaw.com. We will see you soon at the next webinar.